Are they going to risk their job? Are they going to put up $5,000 or $10,000 of their pay when that might be a year's pay or a half a year's pay? Or are they just going to grin and bear it and tolerate it? Hello, everyone. My name is Kurt Mueller. I'm your favorite patent attorney, and we're here with another United States Supreme Court update. Only one case of note today, but it's a consolidated case. It's actually three cases rolled up into one. And so we're going to be reviewing this opinion in Epic Systems Corporation versus Lewis. This is a pretty significant change in employment law in the United States. It benefits corporations at the potential expense of their employees, particularly as it relates to minimum wage or low wage workers. We're going to be overviewing this case and discuss what happens and discuss the change of the law. But it's a pretty significant win for corporations, and we're going to be discussing why. So there were three cases that came up together with one decision, so the fact patterns slightly vary between the three cases. But what's in common is that in all three cases, the employees had a dispute with their employer with respect to wages owed or hours worked or other violations of the labor law. So they wanted to bring a complaint, and importantly, they wanted to bring a collective complaint or a class action complaint because they felt that none of their disputes were particularly egregious in terms of the monetary amount, but if they pooled the complaints together, that they could form a collective action and the total amount would be enough to justify going forward. Well, their employer objected. Their employer said that they had signed a contract as part of their employment, and this contract had an arbitration provision, and said that any disputes between them and the employer had to be resolved at an arbitration proceeding. For those of you who are unfamiliar with what an arbitration proceeding is, it's essentially like a private court. It's usually staffed by retired judges. Sometimes they're lawyers who have been in practice for a while who serve in the role of a judge-like role. But these are private judges that they are registered before the companies that they serve. So the American Arbitration Association, for example, is a well-known arbitration organization that exists. So you have to go through their qualifying procedures to get listed on their list of judges. But it's not the same as becoming a judge in a court, in a normal court where you'd have to be elected or appointed by the legislature. In this case, you only have to be approved by a private association, and different private associations have different rules for how to get appointed to their arbitration panels. Now, arbitration proceedings as a general proposition do tend to follow procedures that are similar to courts in terms of what evidence can be presented and what witnesses can be called, but there are significant deviations. So they can form their own rules in terms of their process that are deviating from a court. And perhaps most notably and most importantly, their decisions are almost impossible to appeal. The arbiter has to get it basically massively wrong in terms of the law, more so than a normal judge would. So to appeal an arbiter's decision is almost impossible. It has to be something that's truly egregious, a higher standard perhaps than would apply to a normal judge. But the theory, at least in principle, is that you've agreed to this and you've agreed to it, so you should be able to agree to a different procedure than would apply in a court. Now, to the extent that the employee actually really agreed to it is, of course, a disputable issue. The employee wants to be employed. They have to sign a contract that has all kinds of provisions, all kinds of rules and procedures. So do they really have the ability to object? Especially if they're a low wage or minimum wage worker, you might reasonably argue no. So they may not really have the ability to refuse, and that seems to be one of the concerns of the dissent in this case. But in any case, they wanted to bring their action collectively. The arbitration agreement said they could not do that. They had to bring individually, not collectively. So each employee had to bring their own complaint. And so there was a potential conflict between laws. On the one hand, the employees said that their action was governed and controlled by the National Labor Relations Act. The National Labor Relations Act, as the name implies, is a law that governs the relationship between employees and employers in the private sector. So this is the thing that sets up hours. It sets up the maximum amount of hours you can work, the payment rules, what jobs are hourly, what jobs can be salary, the exemption rules and things like that. So this basically sets up the framework for the employment rules for private employers. And one of the provisions the employees said is that there was a clause that basically, they argued at least, made a prohibition on collective actions illegal. So they said that this law said that the kind of collective action they wanted to bring was protected under the National Labor Relations Act. The employer argued, in contrast, the Arbitration Act was the governing law that protected that governed the situation, and the Arbitration Act said that it basically dominates every other law. And so this was a conflict between laws, which law governs, and the United States Supreme Court decided on Monday that the Arbitration Act governs. So the Arbitration Act is considered binding, and we're going to go over some of the key decisions that help to illustrate why. So first, we're going to read this part of the majority decision. Now, there is a clause in the Arbitration Act that says, and I'm quoting here, that you can refuse to enforce arbitration agreements upon such grounds as exist at law or in equity for the revocation of any contract. Now, this language actually became very key. What does any contract mean? What does it mean for you to have a ground that would revoke any contract? Well, the United States Supreme Court says, going on down here, that to apply to any contract means it has to apply to every contract. So the only arguments you can make to nullify a contract for arbitration are the kind of arguments that you could make to nullify any contract or nullify every contract. So these are considered general applicable contract defenses that would apply to any contract. And as you can see here, that includes fraud, duress, and unconscionability. Fraud is, as the name implies, that there is basically trickery. Duress is I'm forcing you, so it's not really consensual. And unconscionability is a little bit harder to define, but basically it means the contract is so unbelievably one-sided that the court will not enforce it. That's a pretty difficult standard, and it's a little bit difficult to summarize properly, but that's basically unconscionability. It has to be unbelievably one-sided for unconscionability to be the rule. And so the United States Supreme Court that said that the saving clause in the Arbitration Act, which said the defenses that can kill an arbitration agreement are those that apply to any contract, means only those defenses that apply to any, meaning every contract. So this was considered by the United States Supreme Court to be a specialized argument that would only apply to this particular kind of contract. This is an employment contract. The National Labor Relations Authority or Act only applies to employment contracts, arguably. So because it could only apply to employment contracts and not every kind of contract that could be formed, it's not a defense the United States Supreme Court said could apply to any contract, and therefore the Arbitration Act's saving clause didn't work, because even if this was considered a valid defense in this context, it doesn't matter, because it would have to only be one that would apply in every context. So they've interpreted any to mean every. I think that this goes to show, regardless of how you feel about this particular interpretation of law, how important looking at individual words can be, and how you can look at words and interpret them in a way that might be different than you might expect. So this goes to show sometimes the very pedantic way that language can be interpreted, and that's basically what happened here. A second defense argued by the employees was that there was a conflict of laws. And this is not that unusual. The idea that Congress passes multiple laws that conflict with each other shouldn't be that surprising. In fact, from time to time, Congress has passed things that conflict with themselves in the same law. So the idea of how to resolve the conflicts in law is a well understood issue in contract interpretation or statutory interpretation. What the United States Supreme Court rules here is that the court cannot pick and choose between different enactments. The role of the court is to interpret the law, not to enact the law. So only Congress can pass the law. So basically what the court says is that if there's any way on earth to make both these laws work at the same time, we're going to do that. If there's any way to do it, and we're not going to allow repeal by implication. In this particular situation, the Federal Labor Relations Authority Act was the second law that was passed. The Arbitration Act is the older act. So as a result, they said that the Federal Labor Relations Authority Act could not, by implication, repeal the Arbitration Act. If Congress wants to repeal something, they have to be explicit about it. And if they're not explicit, they're going to make every possible effort to avoid the conflict. As they say here, the reason is a separation of powers and preventing judges from being able to pick and choose between statutes, because that it's an issue of policy. When you have different things that conflict, which one should dominate, that's a policy-based consideration. And the United States Supreme Court is saying that they're not in the business of setting policy, but in the business of interpreting law. Policy is left to the policy-making body, Congress. And so they said here that there is no conflict between the acts because we've interpreted this word any to avoid the conflict, so there's no conflict left, and these both can exist in the same harmony. So to the extent that you think that the courts should try to avoid conflicts, that might be another reason for them to interpret any the way that they did, because interpreting any that way made the conflict disappear. Now, if you think that's disingenuous, 4 members of the U.S. Supreme Court agree with you, but that was the rationale put forward by the majority in the majority case. Another provision of the majority opinion I think is interesting is this provision, which points out that the Arbitration Act has basically been held to beat every other statute that has ever been proposed to conflict with it. So to the extent that you think that this is the wrong decision by the court, it is not an aberrant wrong decision by the court. This has been a consistent trend where the United States Supreme Court has revalidated the Arbitration Act as essentially being supreme to, among other things, as the Supreme Court points out here, the Sherman and Clayton Acts, which relates to antitrust, anti-monopoly provisions that prevent collusion by businesses and price fixing, things like that. The Age Discrimination Employment Act, which, as the name implies, prevents age discrimination as it happens to anyone over the age of 40 years old in terms of employment decisions. The Credit Repair Organizations Act, which deals with companies whose business it is to provide credit repair services. I'm sure you've seen these on TV where they say, we will fix your credit. This is who they're talking about, the Credit Repair Organizations Act. This law is meant to govern their conduct. Securities Act of 1933 and the Securities Exchange Act of 1934. Securities are stocks, essentially, and deal with how stocks are traded and how stocks are sold, and the deals with insider trading and the rules that govern how these things are sold, not only on public markets, but also private markets, because not all stocks are sold on stock exchange. In fact, the vast majority are not. Stocks can be private and handled in just like a typical business relationship, but they're often governed by the Securities Act, and so that would be there. And everyone's favorite law that everyone misapplies is the Racketeering, Influence, and Corruption Act, otherwise known as RICO, and the RICO deals with basically mob and criminal enterprises, but it's massively misapplied or overapplied. As a general proposition. As a famous convict says, it's not RICO. If you think it's RICO, it's not RICO. In fact, to the extent that many courts, when you plead RICO, make you go through a very extra burdensome step of going through a specific pleading, which is not normally required in federal courts. But a lot of courts make you do it in a RICO argument because it's so badly misapplied. But the takeaway here is that all these other acts, they're pretty serious stuff. I mean, antitrust, anti-monopoly, no price fixing, don't discriminate on the basis of age. Be careful in terms of what you are doing as a business if you're trying to repair people's credit, how you sell stocks, insider trading rules, and don't be a mobster. All these acts have been found to be essentially subordinate to the Arbitration Act, as the National Labor Relations Authority Act is upheld or likewise found today to be subordinate to the Arbitration Act. So the Arbitration Act has been getting more and more power over the years. It's also been held that any state law that tries to say arbitrations are illegal doesn't work. So state law, to the contrary, doesn't work. And even Indian tribal law doesn't work. The Arbitration Act has basically been ruled to overrule pretty much everything. So this is one of the reasons that arbitration agreements have become so much more dominant in so many more contracts, and this is only going to expand from here as if this wasn't already a continuing trend. I thought it might also be helpful to read a little bit from Justice Ginsburg's dissent. So this is not the majority opinion, this is the dissenting opinion written by Justice Ginsburg, and I want to read it because I think it highlights some issues Justice Ginsburg felt was caused by the court's analysis here. And I'll quote what she says. The probable impact on wage and hour claims of the kind asserted in this case now before the court is all too evident. Violations of minimum wage and overtime laws are widespread. One study estimated that in Chicago, Los Angeles, and New York City alone, low-wage workers lose nearly $3 billion in legally owned wages each year. The United States Department of Labor, states' labor departments, and states' attorneys general can uncover and obtain recovery. But because of the limited resources, government agencies must rely on private parties to take a lead role in enforcement of wage and hour laws. Writing further, Justice Ginsburg says, if employers can stave off collection and employment litigation aimed at obtaining redress for wage and hours infractions, the enforcement gap is almost certain to widen. Expenses entailed in mounting individual claims will often far outweigh potential recoveries. And she cites one study here that says that an arbitration program would likely have to spend $200,000 to recover only $1,867 in overtime pay and an equivalent amount in liquidated damages. So she's basically arguing that people, especially in low-wage jobs, will not have the money to address their rights because they would have to do so individually, and they just don't have the revenue to do so. Further writing, Justice Ginsburg says fear of retaliation may also deter potential claimants from seeking redress. Further inhibiting single-file claims is a slim relief obtainable, even of injunctive kind. The upshot: employers aware that employees will be disinclined to pursue small claims when confined to proceedings one by one will no doubt perceive the cost-benefit balance of underpaying workers tips heavily in the favor of skirting legal obligations. I think Justice Ginsburg's concerns here are very valid. If a minimum wage employee, say someone who's working $10 an hour, works 40 hours a week, 50 weeks a year, that's $20,000 of pay. After taxes, how much do you think that they have left? Maybe $17,000 of pay. Would they spend $5,000 even, which is pretty cheap for a legal proceeding, to be quite honest? Would they spend $5,000 in a legal proceeding to vindicate being made to work more hours than they should, or being told that they had to work off the clock, or not being paid for time that they should be paid time for? I mean, it's just not financially feasible. And because they can't pull their resources together with fellow employees, I think Justice Ginsburg's concern here is very significant. I think she's correct that employees will be effectively disenfranchised because they won't be able to afford the fees, and employers may feel tempted to push the envelope more than they would before. Now, this isn't completely bad news because, as Ginsburg points out, there are still the states' attorneys generals and states' labor authority, which have the ability to investigate. And there is, of course, private unions who might be willing to fund some of this out of their coffers, and other sorts of non-governmental authorities who might be willing to put the money forward for particularly egregious cases. So, but all those avenues that I just mentioned existed before. They're not new avenues. Those avenues continue to exist, but one of the major avenues that existed up until this moment was employers being able to bring collective action even before an arbiter, and that apparently is now dead. And so there was a avenue that's now longer gone, and that's got to change the cost-benefit analysis according to Ginsburg, and I think she has a valid point. There's also one other item of note here from Justice Ginsburg's minority decision that is worthy of note. She points out quite correctly that individual arbitration awards can give rise to anomalous results. Arbitration proceedings are typically confidential, as she points out, and they don't have precedential effect because they're secret and the results are not published. And even if they are, the arbitration agreements and the rules of arbitration usually prevent them from being given any effect in further proceedings. Now, arbiters are bound by the rules and laws that exist as established by courts, so they can't do anything. If they go completely off the reservation, they can be appealed, although it's very difficult. But it's possible. They are bound by the laws as decided by courts, but they're not bound by each other. So arbitration proceedings are sort of one-off cases that don't have any impact beyond their immediate focus. As Justice Ginsburg writes, as a result, arbiters may render conflicting awards in cases involving similarly situated employees, even employees working for the same employers. Arbiters may resolve different questions, such as whether certain jobs are exempt from overtime laws, and with confidentiality and no precedential value provisions operative, irreconcilable answers will remain unchecked. So that, my friends, is a review of this case that came down, Epic Systems Corporations versus Lewis. As I feel I've hoped to make clear that this is a fairly significant change in U.S. corporate law. I don't know the extent to which arbitration agreements are in private employment contracts. My suspicion is, as a general proposition, and I could be wrong because this is outside my knowledge, but I would suspect, if I were guessing, that they're not in that many contracts as of today. But with this decision on the books as of now, I would strongly suspect that private employers will be putting them in their employment contracts and their applications for employment going forward, to the extent that they haven't so already, because there's not much disincentive to do so. To the extent that the employees had alternate avenues, they would continue to have those alternate avenues anyway, but the arbitration agreement is going to be enforced to the maximum extent possible, as made clear by this, and any sort of wage claim, hours claim, lack of pay claim, unfair working condition claims, and potentially even sexual harassment claims, as it was pointed out at one part of the opinion, potentially even those might have to be resolved by private arbitration proceedings. And a minimum wage worker or a low-paid worker, if they're only making $20,000 a year, $30,000 a year, are they going to risk their job? Are they going to put up $5,000 or $10,000 of their pay when that might be a year's pay or a half a year's pay to redress a perceived minor violation? Or are they just going to grin and bear it and tolerate it? I think Justice Ginsburg has a very fair point that this leads to some potentially negative policy implications. One item of note I would give here is that there is potentially a separation between the issue of policy and the issue of law. So to the extent that you think that this is a bad policy outcome, you may wish to try to separate that from being a bad legal outcome, or you may not. Obviously, 4 members of the United States Supreme Court, in their minority opinion, feel that this is a bad legal outcome too. But you could at least in principle say that this is a bad policy outcome, but the law dictates this result. To the degree that you think it does or does not, I'll leave to your judgment, but those are potentially separate questions that are worthy of being considered. If this truly, let's just assume for the moment that this truly is the will of Congress, and this is a proper interpretation of the law. Well, if Congress set it up this way, Congress has the right to set it up this way as the policy makers. So if this is an accurate statement of the law, the fact that it's bad policy would be laid strictly at the feet of Congress. So that's what I'm trying to say when I say the policy is separate from the law, or at least potentially. And I also note here that the United States Congress can overrule this decision. A lot of times people say, you can't overrule a decision in the United States Supreme Court. Well, that's usually not true, actually. You can overrule a statutory decision, and this is a statutory decision. It's based on statute. Congress can overrule this decision by passing different laws. So this is not a constitutional issue. It's something Congress can, if they are so inclined, change by legislative fiat. They can pass a law that makes arbitration agreements illegal in employment contracts or otherwise change the balance in the policy arena. So if you don't believe that this is a correct decision, you can lobby your congressman to try to bring about a change in the law, because that is within their power, because this is a statutory case and Congress has the right to change the statute. So I hope this was a reasonable overview of this case and outlaying its significance, and overviews of the majority and minority opinions, and trying to explain the change in the law and how this might impact the private employment situation based on an analysis of the law. I'm going to leave it here for now. As always, my name is Kurt Mueller. I am your favorite patent attorney. And I hope you have a good evening and this finds you well. Until later, my friends, cheers. Bye.